So we have a good number coming in. We're at 206 participants. So I think we can get the ball rolling here because we have a lot to cover. So I'm Charina Garcia. I'm an immigration attorney practicing in the San Francisco Bay Area. I work for WR Immigration, and I'm also a member of the Commission on Immigration. So today we're excited to present a timely webinar entitled Taxigration: what you always wanted to know about the intersection of tax law and immigration law. This is sponsored by the ABA Commission on Immigration and the ABA Tax Section. During today's program, we encourage you to ask questions of our panelists through the Q&A, not the chat function. If you see the controls at the bottom, you'll see that there's a Q&A function. We'll be monitoring that and we'll be addressing the questions at the end of the webinar. We will also be sharing a recording of this program with everyone who's registered so you can share it widely with your networks. Our bios will also be available on the YouTube recording. So why did we choose this topic? It's a very complicated topic. To be honest with you, as an immigration practitioner, anytime anyone asks me about tax, I run away. And I say, I don't know, you need to talk to a tax professional. And I've heard the same thing from tax professionals. They also have the same reaction. So many times we're unfamiliar with the terms and concepts in immigration law and also in tax law. So what is taxigration? It's actually the intersection between tax and immigration law. So in this webinar, our panel of experts are going to explore taxigration as it pertains to individuals who are undocumented, asylees, refugees, temporary visitors, workers, students, investors, and really how tax compliance can impact their future immigration benefits. We'll be talking about the tax requirements for immigration clients, what they need to do to resolve any tax issues, and how to guide clients to ensure their taxes are properly filed and paid. Now, this is only a 90-minute webinar, so this is only an overview, okay? This is not going to be a deep dive into taxigration. What you can do, and Sarah's going to discuss the book that the ABA Tax Session has put out. That's a really good resource, which actually could be useful to everyone. But we hope at the end of this webinar, you'll have the necessary information to navigate the true complexities between tax and immigration systems, and what are the tax issues commonly encountered by non-citizens. So I'm going to go ahead and introduce our panelists. Their bios, again, can be found on the YouTube recording. So Wafa Hoballah, attorney from WJH Law Group. Sarah Lora, Associate Clinical Professor of Law and Director, Low Income Taxpayer Clinic, Lewis and Clark Law School. We also have, who is also the author of the book, and then Sam Rock, attorney, Rock Law Group, also a co-author of the book. And then Sakina Tillman, Assistant Professor of Law and Director of the Tax Clinic, University of the District of Columbia, David A. Clark School of Law. And with that, I'm going to let Sakina take it away.
Well, thank you so much for that. So the first thing I'm going to talk about is what is the I-10 program? So the I-10, it's abbreviation for the Individual Taxpayer Identification Number. It is a 9-digit number that someone that is ineligible for a Social Security number they apply for. And you are able to apply for this by using the form W-7, it's the IRS form. The reason why someone will apply for this when they're not eligible for a Social Security number and they need this 9-digit number to apply, to file for a tax return. So there's several reasons. Someone that's considered a non-resident alien that's claiming some form of reducing their income under an income tax treaty. That's why they will apply for one. Second, if someone, again, is not eligible for a Social Security number, but they need an identification number to file an individual tax return. Two, someone that's a non-resident alien spouse that is filing a joint return with someone where their spouse is a U.S. citizen, they will file for a I-10 number. And someone that is a U.S. Resident alien, which we will later discuss in this presentation, that meets the substantial presence test, they will file for a I-10. The process takes about 7 weeks for the IRS to process the the W-10 form along with the substantiating documents to process that. And it lasts for 5 years, and you can renew it after it has been expired.
All right, let's move on and let's go to Wafa, and she can tell us how to apply for Social Security number and also for children.
Hello, everyone. It's often a question that parents holding non-immigrant visas or others that question, how can I get a Social Security number for my child? And usually getting the Social Security number is not an easy process, except if the children are under an asylee petition, direct or derivative, or sometimes a family-based immigrant visa. And the way it's done is usually if an asylum application has been filed and the child is a derivative or it's a direct application, they can file for an employment authorization card after 180 days of the application being received by the asylum office. And once it is approved, then a Social Security application or card can be applied for by going to the Social Security office and providing the two IDs that they require. Another way of doing it, if a child of a US citizen is born overseas and doesn't qualify to be given a citizenship as born overseas, then many times the parents, if they have accessibility to get a tourist visa for the child and they come to the United States, then they can apply for an I-130 immediate relative petition for a child with an application to adjust status. Then with the employment authorization application that is joined to the I-485 application, then they can get that done, and usually they can get approved before an appointment for an adjustment of status, and then they can get a Social Security number. It is really limited to children to get a Social Security number. Also, to note that children under non-immigrant employment-based visa categories like an H4, which is a derivative for an H1, or an L2 for an a child with a parent on an L1 category, or an E2 treaty investor child, or an F2, which is a children of student visa holders, they cannot get an SSN number. That's for that part.
Thanks, Wafa. Now we'll move back to Sakina and to talk about the filing status for taxpayers, spouses, and dependents.
Thank you. And so the first part is that if you are a non-resident alien, there are a few filing statuses that you are eligible for. The first one is single. That's someone that technically doesn't have any dependents. The second is a qualifying widow or widower. That's someone that has dependents, but they had a spouse that died during the tax year, or married filing separately. And someone that is a non-resident alien, they can be eligible to file what's called Form 1040 NR. NR stands for non-resident. Someone that files a 1040 NR is someone that did not meet the substantial presence test or the green card test, which we will later discuss in this presentation. But for someone filing this form, they're engaged in a trade or business in the United States. Although they're not a US citizen, they have to file that income and be subject to tax. Now, in addition, if someone is a non-resident alien spouse and they have a US spouse, there's two things that they can do. One, they can file a Form 1040 with their US citizen spouse. However, they'll be required to file, file to get their I-10 number. And when they get their I-10 number, they can file the 1040 with their US spouse. However, they'll be required to report all of their worldwide income under the Internal Revenue Code 61. Or the US spouse that has a non-resident spouse, they can file a 1040 married filing separately without their non-resident spouse being reported on their tax return. As far as dependents, and that's for the next slide, you can change the next slide. Yes. And so for non-residents that have dependents, you're able to claim your dependent if you're a non-resident alien, if you are a US national, if you are a resident of Mexico, a resident of Canada, a resident of South Korea, and India. In those regards, if you are a resident of those countries that I just mentioned, you are eligible to claim your dependents on your tax form, which would be 1040-NR that I recently just talked about in that case. And how it's treated from a tax purpose, when you are filing a 1040-NR, you'll be subject to tax up to 30% of the income that is claimed on the tax return.
Thank you, Sakina. Now we're going to move on to Social Security benefits. So Sarah, why don't you take that away?
Right, so the question came up for the purposes of this panel about Social Security benefits for non-citizens living abroad. And the general rule is that no, non-citizens living abroad are not entitled to receive Social Security benefits. However, there's a small exception, if you even want to call it an exception. Legal permanent residents of the United States residing outside the country temporarily can receive Social Security benefits. The general rule is that they need to come back to the United States every 6 months to show that they are still residing permanently in the United States. But legal permanent residents in general are entitled to receive Social Security benefits. However, they do need to permanently reside in the United States. Another question came up is whether a taxpayer who has obtained a Social Security number after reporting income with an ITIN can correct their Social Security earnings record. And prior to being a tax attorney, I was in the farm worker program at Legal Aid Services of Oregon, and I handled these cases. And the answer is yes, you can do Social Security earnings record corrections. And it's one of those very satisfying cases where not very much work goes into this application, the SSA 7008, to correct earnings. You attach the tax returns. And this is why it's very important for our undocumented taxpayers to do their taxes so that they can prove that they had these earnings. And then voila, they get their increased Social Security benefits completing this process. And the question comes up, but what about the 3-year limit on correction? That is not applicable in these types of cases. I don't remember exactly what the rule says, but there's exceptions for when the earnings were reported on tax returns, or if a W-2 was issued, then, and that is correct, then it can be updated in the system. One issue that I do want to bring up is there is a very, very small risk of prosecution in these cases. It is something that we do raise with our clients so that they're very aware that in the event that there was any crime committed with the use of the Social Security number prior to obtaining a valid Social Security number, that they're aware that there's a very, very, very minuscule risk of prosecution, and therefore they might consider waiting the statute of limitations on those crimes. And generally we suggest waiting 6 years. And clients do or do not follow that advice. Next slide, please. So another issue that comes up is what to do if you've been using an ITIN to file your taxes when you are undocumented, and then you do adjust status or some other way receive a valid Social Security number. What do you do? What are the steps? Step 1, stop using the ITIN. You do not use an I-10 after you receive the Social Security number. The I-10 is not valid anymore. And you use the Social Security number for all future tax filings, even if any underlying work authorization is expired or anything like that. Once that Social Security number is issued, that is that taxpayer Social Security number for life, and they should continue using that forever. You must also inform the IRS of the updated Social Security number. There is a process you can look, there's a link in the slides for the process to update the IRS on this. And this just helps with potential audits in the future. We have lots of situations where our taxpayers get their Social Security number and are filing for the first time with their Social Security number, but they haven't told the IRS that they've gotten the Social Security number. It often results in audits and delays in their receiving their credits for their kids. Next slide, please. We are now going to, I have a bunch of slides on the earned income tax credit and the child tax credit to talk about kind of some of the immigration implications. I will fly through these slides. I don't want to deep dive. They do look like complicated slides, but I'm just going to point out several issues. So let's go to the next slide. First of all, earned income tax credit and the child tax credit are refundable tax credits enacted to reduce poverty for low-income working families. And these credits have been proven to sharply decrease poverty. I have two infographics. The first one talks about the expansion of the child tax credit for 2021. And this the large expansion of the child tax credit dropped poverty in children by 3.1 million children. Huge impact for anti-poverty purposes. And the same thing for the earned income tax credit and the child tax credit. Not just in 2021, but these statistics are from 2018, lifting millions and millions and millions of people out of poverty. Next slide. So the earned income tax credit has a few threshold issues. The main thing I wanted to touch on for the purposes of this presentation is that the taxpayer, the spouse, and the child all must have a valid Social Security number, meaning they all must have some legal status in this country. This results in, for mixed status families, oftentimes citizen children not having access to the earned income tax credit because one or more spouses is undocumented. And it results in that family not having that anti-poverty protection from the tax code. In addition, the filing status comes into play with immigrant families because one or more spouses may not be documented. There is a temptation, largely on the part of tax preparers, not our clients, to try to kind of loophole around the problem with the earned income tax credit that you must be married, filing jointly, head of household, single. You cannot get the earned income tax credit with married filing separate. So it just kind of locks in those families with mixed status households into not receiving the earned income tax credit. And I think Sam's going to talk a little bit more about that later. Next slide, please. And then again, just touching on the connection between immigration law, residency test is really important here. The child must have lived with you in the United States for more than half the year. This prevents a lot of our immigrant families who are supporting dependents in, for example, Mexico or Canada from receiving the earned income tax credit. Next slide. And then so for the child tax credit, there have been some increases in the amount of the credit. For 2021, it was expanded significantly. It will come back to what it was for the Tax Cuts and Jobs Acts from 2018 to 2025. But the point for this presentation is that the child must have a valid Social Security number in order to access this credit. So while the parents can be undocumented, not have valid Social Security numbers, one or more of the parents or the taxpayer and the spouse, the child is the one that we're looking at. Does the child have a valid Social Security number? Next slide, please. Oh, wait, stay there. Sorry, go back. One humongous important point I have here in subsection 3 and with a parenthetical, it probably deserves its own slide and in bold, because I have seen where a Social Security number becomes available between April 15th, the due date of the tax return, and October 15th, the due date of the tax return, when the with an extension filed. And if an extension has not been filed, that family is out thousands of dollars. So it's extremely important to encourage your taxpayers and their families to file an extension in the event the child or either of the parents are waiting for a Social Security number to come through. So for example, you have 2 parents and a child. The child has a Social Security number, the taxpayer has a Social Security number, and you're just waiting on that spouse's Social Security number to come. They would be eligible for the earned income tax credit over $6,000 for a family with 3 children if an extension was filed and it came between April 15th and October 15th. So humongous important point. Again, apologies that it's a parenthetical under subsection 3, but I wanted to just highlight that. Next slide. And then again, the residency is going to be important for immigrant taxpayers, immigrant families, that the child needs to live with you in the United States for more than half the year for that child to qualify for the child tax credit. Again, this prevents our families that are supporting dependents outside the country from receiving this anti-poverty tax credit. Next slide. And it's me again. Okay, substantial presence test. Let's move on to the next slide. So, oops, yep. So as Sakina was talking about earlier with our resident and non-resident taxpayers, how you determine whether that taxpayer is considered a resident for tax purposes is by the substantial presence test. And just to be clear, that a resident for tax purposes is completely different than a legal permanent resident or any type of legal status related to immigration. A resident for tax purposes simply means that they have resided in the United States for the requisite number of days, considering the substantial presence test, which is quite complicated, and I will get into it now. And one thing I did want to point out, which took me a long time to figure out on my own, but I wish somebody had told me sooner, that for low-income taxpayers, substantial presence is 99.9% of the time good, better than non-resident. And for high-income taxpayers, substantial presence is bad. And so just to have that in your head, for me, I was like, oh, who cares about the substantial presence test? I don't even get it. But the idea is that for your low-income taxpayers, the benefit of having been considered a resident is significant, as Sakina pointed out earlier. So what is the substantial presence test? You have to be residing within the United States for at least 31 days in the current calendar year, and subsection 2, 183 days in the current calendar year, or, oops, back up. Thank you. I'm reading off the slide. I can't do the substantial present test from memory. 183 days counting the sum of the number of days in the current calendar year plus 1/3 of the days in the preceding calendar year and 1/6 of the days in the second preceding calendar year. So it's a calculation of the number of days residing in the United States, current year, previous year, second previous year. And so, but I kind of think in my head, has the taxpayer been in the country for about 6 months? If so, most likely they've satisfied the substantial presence test. If not, they haven't. Next slide. I could see, are we just trying to move me along here? Is that the deal? Okay, I'll go faster. So consequences for low-income taxpayers. If the low-income taxpayer does not satisfy the substantial presence test and is not otherwise considered a resident of the United States for tax purposes through the green card test or first-year election, they will be treated as a non-resident taxpayer. And as Sakina mentioned earlier, there's no standard deduction. So that's, you know, they're paying on every single dollar they earn, basically. Personal exemption is not allowed according to IRS guidance. However, some practitioners have taken the position that section 151B5B would allow for pre-Tax Cuts and Jobs Act's personal exemption amount. And I know from our other co-author, Robert Nassau, who's looking at this issue, and myself, that the IRS has accepted this argument at the lower levels. If you win at the lower levels, you're good. If it goes up to appeals, generally they will reject this argument. But I think that Robert Nassau is going to be doing some litigation on this. And so it's very exciting that we might be able to get that personal exemption for non-residents. But in general, I think the IRS's position is that it's not allowed. No married filing, joint filing status, and no dependents unless they're from Canada or Mexico, but no monetary benefit for those dependents because of the Tax Cuts and Jobs Act. The dependent exemption amount is 0 temporarily. Next slide. Okay, and this is for Wafa.
Well, coming to high income people, non-residents, tourists who come to the United States. We have so many of them who have homes, who have certain investments here in the United States. If they meet the substantial test for that calendar year, then they would be considered as residents for the purpose of paying taxes. And the IRS would be after them. It's always advisable to speak to the client and advise them to coordinate with their CPAs or tax consultants so that they can monitor the number of days that they stay in the United States. The substantial presence test is computed on a yearly basis. So they have to be quite aware of that. Next slide.
Thanks, Wafa. So now we're going to move on to, I think we have a lot of questions about this. How does tax compliance affect applications for relief? So we have Sam here to show us his house of cards. Next slide, please. Sam, you're on mute.
That's how you all wanted it, but I'm here. So the reason why some of these are on here, like for example, the child tax credit, for many reasons, is because in cancellation cases, sometimes the judge or a non-LPR case will, depending on the jurisdiction and the administration, we'll look back at 10 years and say, you know, for your 10 years prior to when you filed the application, you know, did you have good moral character? And for a while, tax returns were a real hot button. The, you know, trial counsel had figured out that there was, I think Sarah said a loop, you know, tax preparers were fairly good at finding a loophole to avail people of the EITC. Although my perspective is that there was sort of a culture within the undocumented preparation industry where children were claimed, it's a different issue, but children were claimed to get the child tax credit when they were not living with the child. So when you're, or living with the parents, so when they're looking back 10 years, there were a lot of children that may have been in Mexico or Guatemala or another country where in Guatemala, they weren't entitled to receive an ITIN, even if they were a dependent, but they were being stated as if they lived with the taxpayer. And so if you had a case and you were in proceedings and you looked down and there were a bunch of children on your tax return, and the box was checked that they were receiving the child tax credit, in many years, that meant that the person receiving $1,000 credit per child. And that was a huge issue because undocumented people could claim it, and they could claim it when the child had an ITIN. The child did not need a social. That changed in 2018. So that kind of like cleared that issue up a little bit, at least with regard to how the IRS looked at it. So if you have that situation prior to 2018 and you're practicing an immigration case and you see a bunch of children stated on a tax return that are your client's children that live abroad, or they are not your client's children, and there are certain family relations that do qualify as a qualifying relative, for example, a niece or nephew or a grandchild, but not a cousin. So sometimes I would ask them, what's your relationship to this person? And they would say, well, it's essentially a cousin. And I would say, well, it's that one doesn't qualify. So, and you may have that situation for your clients many years in a row. And so to resolve that, you would just send them to someone and say, figure out which exemptions can lawfully be claimed for the child tax credit, and then remove the other ones via an amended return, a 1040X. And there's an explanation in a 1040X, and I put something very benign in there. Like when these cases are referred to us, I put, children removed for the claim as dependents or child tax credit. I don't really lean into why it happened. In some cases, when I thought that my client really had no idea, and in fact, they did not even know who the people were on the tax return, I would say that I thought that the tax preparer took liberties with my client's tax return. And I would talk to the immigration counsel before who's handling the case and tell them what I see or what I saw. So the reason why I skipped down to number 3 is because that's the one that I think you see the most in these cancellation cases when you get a judge that wants 10 years. False dependents, which is the joker, you see that on occasion. That's kind of an easy one. Again, you just send them out to the tax preparer and get them to remove them. And sometimes it just relates to the definition of who could qualify as a qualifying child. Like, it's sometimes people don't get the difference between a cousin and a niece or a nephew. So like it does get blurry. Another one that I see that's very common, and we get these all the time, are understatements of income. This happens a lot when you get cash workers. And what we do is, it comes up in 2 contexts. It comes up if someone is applying as a petitioner and they're applying for an I-130 for a family member, and they've understated their income and they don't meet the threshold for an I-864, and they come in and it says they made $15,000 and it seems to match the amount that is the maximum EITC. You just ask them, how much did you really make? And then you put it on there, stated as cash, increase their Schedule C, and they may have to pay back some EITC. That's common. And what I've not seen in those cases is that I've not seen a prosecution of those cases. I have had a case one time when we basically, a person had claimed a bunch of earned income tax credit that they weren't supposed to claim, because the person filed head of household when they were really married to someone undocumented, and then claimed the EITC for many, many years. And the judge wanted to see tax returns that were combined. And so we combined them. It removed the EITC. This was after when the Internal Revenue Code was changed to preclude retroactive claims to the earned income tax credit. It used to be that once you got a social security number, you could retroactively claim the EITC for years when for back to the 3 years, so the statute of limitations. But that was changed. And so then you couldn't retroactively claim the EITC for purposes of getting a refund, but you also couldn't claim it 10 years back to claim the EITC to basically sort of reduce possible tax debt that was created when you removed the additional shock tax credit. And so for my clients, that was the largest problem with that change, because not getting a refund is one thing, but getting a tax debt that's basically created for $4,000 for basically 10 years, because you can't claim the EITC, and that having interest and penalty on it 10 years later. I mean, those were big numbers. And so I did have one offer and compromise denied one time on one of these cases, because the examiner basically said, look, we're not going to let you get rid of your tax debt because, we believe you committed tax fraud. So, or some form of noncompliance. So understatement of income is relatively easy to fix. I do have an aside here. I have cases where people are referred to me when they're living abroad. And for some reason, this is very common with lawful permanent residents that are living abroad, and they want to file an I-130 for a family member. They're not filing tax returns because they're outside the country, and they have talked to someone that said, you don't need to file a tax return if you live outside the United States. An income exclusion is different than not having to file. And there are lots of times when your income can be excluded. But so then we have to go back and file their tax returns. And this can be a whole big thing, because they may have foreign accounts overseas, and then you get into, some particular programs. So that comes up a lot. I don't really know why it is, but I do see that a lot. And I see, people just understating income when they're living abroad, and it typically comes up always in the context of an I-130. So the next one on this list here is the King of Hearts, filing as head of household by the USC LPR when married to an undocumented individual. So this is common, and you'll see two tax returns that have the same address. Sometimes the USC will have claimed the children that have social security numbers, meaning US citizen or LPR, whoever has the social and a mixed status family, they'll claim the children with a social security number. And if the undocumented spouse is working in cash, they may not file a return. And if they do, it might not be all their income, but they'll have the same address. If they're married, the only two choices when they're living together are married filing jointly and married filing separately. And as Sarah said, if they file married filing separately, then they're not eligible for the earned income tax credit. So this is done a lot and in the preparation industry. And I ask my clients always, why do they do this? What did the tax preparer tell you? And they say, well, they said, I can't file with my spouse because they're undocumented. And I said, okay, that's fine. And so then I just, write it on the tax return. And again, something very benign. I write in the explanation, combined tax returns of the individuals. As a result, earned income tax credit was disallowed, and we fix it. In my experience, in all but one particular case, and I'm not going to say what court, but this person was a really good private immigration lawyer, knew a lot about the tax benefits, switched to the government, knew the tax benefits, and after we resolved revised and amended the tax returns, this trial counsel still said, well, this stuff all happened before, and it's great that they resolved, but my argument is that the good moral character is still, they're not going to pass the test. So, but that's the only time when I've ever seen resolving tax returns not going through an immigration court. I'm not going to say that always is the case, but I would say that's best practice. If you've got some tax returns that you don't feel 100% about, get them reviewed and get them essentially cleaned, and then you can go sort of proceed and talk to trial counsel and see what's going on before you get in there. The last one that I see, and this one is one to be very cautious about, is sometimes your children, your clients might loan a social security number of a child to a neighbor or a family member and split the refund with them. And sometimes that's fine, and sometimes it's not fine. So for example, if they live with the grandmother and the grandmother supports the children and she's the worker, and the grandmother could claim the child for the earned income tax credit because they live with them all year long, they support the child. Now there are other times when they loaned them to a neighbor or something like that, and then they split the refund. That would not be appropriate. So if you get your client's tax returns and they do not have their children that have social security numbers on them, you should ask. I had an immigration lawyer call me one time just to tell me a war story, and he said his client got on the stand and basically he didn't know this was going to happen, and they asked him, why aren't your kids stated on your tax return? And he said, well, I loaned them to my neighbor and then we split the refund. And he said, obviously the case was over right then. We did not prevail. He did not, but those are the big examples. I think it comes up in NATs also. They can go back 5 years and they can also go back 10. In adjustment cases, there's not really a good moral character element. People talk about discretion, although I've never seen it that way. Sarah did find some interesting case law that indicated in VAWA cases, is that right, Sarah? In VAWA cases, one of Sarah's interns found this, and it's touched upon in the book, I think, that element can come in, but in a typical adjustment case. But how it comes up in adjustment cases is the people had been married for a number of years, and then they weren't filed married and filing joint or married filing separately when somebody was filed as either single or had a household. And then the question is, were you really married? So, that's sort of the context I see it in the adjustment case or in an I-130 consular processing case.
Thanks, Sam. We'll pass it along to Wafa, who could talk about it in the asylum seeker context.
Well, my slide cannot beat Sam's slide, and the way it was said, which was great. It's so simple. It's about the tax compliance that asylum seekers can or could face as they adjust their status. This often happens as asylum seekers have been working for that year, and then they file for their adjustment of status, and they either haven't filed taxes, or they have filed as non-resident, or they have taxes that are overdue. And it's always an issue, and it depends how the adjustment officer can look into it, whether they can give them a chance for a repayment plan or to file back taxes. And if this issue is not resolved, this could be considered, against the asylee, and the application could be considered either abandoned or denied.
Thanks, Wafa. So we'll move on to tax obligations for non-immigrants. So Sarah, why don't you lead us off with H-2 workers?
Okay, next slide, please. So for H2 workers, we do see a lot of H2 workers, especially in the farm worker programs. There are no payroll taxes, whereas for H2B workers, there are payroll taxes. This just happens to be a little piece of the H2A law that no payroll taxes. There's also the issue, there's no mandatory withholding unless both the employer and the employee agree, which generally turns out to be that there's no withholding. And so what happens is that the H2A workers are often subject to tax, and especially if they are not considered residents, if they have not complied or if they have not satisfied the substantial presence test, they're often walking away with owing federal income taxes. And again, the amount of tax is largely dependent on whether the taxpayer is considered a resident or not. Next slide. And this is for Wafa.
Okay, this is back to me. I will go over the B visa, the L visa, and the F visa, and the tax obligations for those. So as we know, the B visa is a visitor visa and could be for business or for pleasure. The B1 is for business, and the activities could be for business meetings, consultations, conferences. Sometimes they come executives to negotiate a contract or to participate in a short-term training, for example, if they're buying machinery. And the training shouldn't be for employment, as we know, but just for the purpose of exploring, for example, how these machines or planes work, or sometimes for settling an estate. This B visa, we have a B1 also that would allow certain holders to work. For example, a B1A, or which is for a domestic servant of a non-immigrant person, or a B1B, which is the same for a domestic servant for a US citizen. For example, someone who is residing overseas, a US citizen, and is coming back to spend a vacation here in the United States, they bring their domestic worker with them, which could be a butler, it could be an assistant. The B1 domestic servant has a special way of or a special application that has to be submitted at the country of residence. For example, if someone is living in France, they will submit it with the US Embassy consulate over there, and they have to comply with certain requirements as a contract with the employee, and also a commitment by the employer, who is either a non-US or US citizen, to pay the servant in the United States the at least the minimum wage of wherever they would be staying at, for example, in California or in Florida, and they have to pay taxes on that. So it's always important to advise the client that they have to arrange for that payroll to be done when they arrive to the United States. Not sufficient to just pay the salary for the period that they would be here in the United States, but they also have to pay the taxes on it. And that's also always important. For example, if they want to extend that visa, they have to show that they have paid the current rate, and there is a pay stub along with that. Now, the B2 visa, a visitor for pleasure, always, as we know, a B2 visa is not permitted to work in the United States. However, the issue of the income comes about when there is an extension of status. Someone who's coming here on a B2 visa, for example, or a B1, and they need to extend the status. And for some reason, either for pleasure or they had a medical issue. So the question comes, how can you support that extension of status application? And often this application that is filed, and there is no financial statements with it. So we often get a request for evidence. I mean, we do file that, but some of those clients, they file it on their own, then they come to us and say, oh, we received a request for evidence that we need to supplement the application with financial documents. And usually, if they don't have a bank account in here or some investment in the United States, then we need to seek documents from overseas, which could be bank statements for the last 3 months, along with a document from the bank officer stating that the account is valid, they have enough in US dollars. And also, if these documents cannot be provided, then an I-134 is always recommended for the sponsorship, a co-sponsor, that there is someone in the United States, a green card holder or a US citizen, who can step in and provide that sponsorship. And here is also an issue of tax compliance, that they have filed for taxes, that they meet the threshold for that sponsorship, and they will have to provide the copy of their tax returns for the year before, along with also 3 bank statements, the most current ones. Next slide, please. Now we come to the F visa, which is a student visa, as we know, that allows foreign nationals to pursue an education in the United States. F1 visa holders are usually allowed to work in the US under 2 categories: the CPT, which is the curricular practical training, or the OPT, the optional practical training. The curricular one is often done when someone is still in school and the training is related to the curriculum that they are studying. The optional practical training occurs after a student has concluded the studies and they are provided a training for either 1 year or renewable and extension for 2 years on a STEM basis. Now, the FICA tax exemption, which is the Federal Insurance Contribution Act, mandates a payroll tax on paychecks for Social Security and Medicare. However, there are exemptions to that if the employment is on campus and the student is employed up to 20 hours a week, or if it's an off-campus student employed allowed by USCIS. And the practical training student employment on or off campus, there are certain requirements on that, but I won't go into details on that now. The next slide, please. Now, the L visa. The L visa is a temporary intercompany transferees who can come or transfer to the United States under managerial positions or executives or have specialized knowledge. Now, as we know, the L visa is in 2 parts: L1A for business executives or managers, or the L1B for specialized knowledge or employees. Now, the taxable income for L1 visa holders are also subject to the presence test, and many L1 holders are not aware that if they meet the substantial presence test, they will be considered as residents for tax purposes. And that could include interest paid, dividends, compensation, income from real property held for investment, and their worldwide income as well. Next slide, please. Okay. I'm not sure if this is mine.
Yeah, this one's yours too, Wafa. Next slide.
Next slide, please. Okay. This one, it's of 2 parts. It's about US residents or green card holders, and I will talk about the green card holders overseas. Is, as we know, required to file the US income tax return and report any worldwide income. Examples: employment, service income for any source, interest from bank account or investment, gains on property sales, wherever located, dividends from companies, wherever located. So many green card holders who are overseas, they think that, you know, they can avoid that, but it's not the case. And they do have an exemption when they file taxes up to $112,000, and anything above that, they are required to pay taxes on that. Now, another issue that I would like to bring upon is filing, reporting taxes under FATCA. Well, FATCA is the Foreign Account Tax Compliance Act, which require foreign financial institutions and other non-profit entities, non-foreign entities, to report foreign assets held by U.S. account holders. Any U.S. resident or a U.S. citizen who is living abroad or has still nexus to their original country or country of birth, if they try to open an account with any foreign institutions, they're always asked if they are U.S. citizens or green card holders. And the banks require them to comply and fill in and complete a FATCA report along with the W-9 that they have to sign, and that is filed directly with the IRS by the bank itself. And that is the way that the US government imposed it on governments overseas through their banking system, so that they can control tax evasion and make sure that all US residents and US citizens that have still nexus overseas, that they comply and file taxes on their worldwide income. And that's also one of the reasons that we have seen in the last 10 years or more, that banks overseas avoid to open bank accounts to US citizens and US residents, because they do not want to be involved in all of those tax issues and reporting. Now, the FBAR, which often happens, and that your tax consultants, CPAs will comply or let you know about it, that the foreign bank and the financial accounts reports that they file it for financial crimes. That's for security purposes and for terrorism. Next slide, please. I think that's it from me.
Sarah, you want to talk about the book?
Sure. So Sam and I, together with Robert Nassau, wrote a book about all of these issues, and we're really proud of it. We think it's really helpful, and we think that it's particularly useful for practitioners who are trying to determine the tax consequences for their immigrant clients. And it's very practical. It has lots of examples, and it's all current and up to date as of now. So we might have to update it really soon. But yeah, we had lots of students help us work on it to make sure all of the citations are correct. So it's a very useful, handy guide. We do have a 20% discount going on now. It's TX1019 DISC. Again, I think I'm very proud of it, and I think that it will be useful for your practice. Very short and sweet, and very much gets to the point of all of these issues and more.
Thanks, Sarah. We have quite a number of questions, and we have some good amount of time to go through it. So I'll just go ahead and read off the question. So Sarah, for this one, can an individual claim the SSN contribution if they filed tax returns using an ITIN?
Yes, so they would, I think what this means is, can they correct their earnings to get, use their Social Security credits towards retirement or disability benefits? And the answer is yes, they would have to get some sort of legal status and a Social Security card in order to correct their earnings to include the earnings from when they did not have a Social Security number. But the answer is yes.
Okay, Thanks. And then Sakina, this one's for you. For ITIN applications, does an undocumented immigrant need to show why they need an ITIN? For example, show that they need to pay taxes on wages or show proof of a savings account. I have heard that the W-7 application will be denied if they don't. And number two, how long is the IRS taking to adjudicate W-7 ITIN applications? You're on mute, Sakina.
Sorry about that. Yes, and so for the I-10 applications, when you are completing the form W-7, it's just asking the reasons why you are requesting an I-10. And so there is a few reasons why someone will request an I-10. The first is that it's a non-resident alien that's required to get an I-10 because maybe they're trying to claim some type of tax treaty benefit on their tax return to reduce some type of income from another country. Second is that it's a non-resident alien that's required to file a U.S. tax return. And that's what we talked about earlier today, where someone has some income that's effectively connected to the United States. The third reason is a U.S. resident alien that's required to file a tax return based on their presence in the U.S. based on substantial presence test. The next is if it's a dependent of a U.S. citizen alien that doesn't have a social security number and they're trying to claim a dependent. The next, if it's a spouse of a U.S. citizen and that spouse is a non-resident alien and maybe they're trying to marry filing jointly for tax purposes, that spouse would need to file an I-10 as well as a non-resident alien or a student if they're here for particular reasons for education purposes, or dependent or spouse of a non-resident alien with a U.S. visa. So those are the reasons why someone will file for an I-10. As far as the adjudication, it takes about 7 weeks for the IRS to process the I-10 applications.
Okay, thanks. And
You're
then there
welcome.
was another question about the countries, I guess, about claiming dependents on tax return. If you could just recite those again.
Oh, absolutely. It is one, if you are a U.S. national, resident of South Korea, resident of India, Mexico, and Canada.
Okay. And then maybe Sam, you can answer this one. If someone used the fake social security number, can they do the same SSA 7008 once they get a valid SSN, or Sarah?
That's a Sarah question.
Oh, Sarah question. Okay, Sarah.
The answer is yes. So again, yes, if you have worked and paid your payroll taxes while working in the United States and you're reporting that income on your tax return, even if you're not reporting the income, the money's still being taken out of your check and paid over to Social Security Administration. Medicare and Social Security benefits are taken out of undocumented workers, and they get to access those benefits once they have adjusted status in some way or gotten some sort of legal status. They can then adjust their earnings record to include that and would get benefits because of that.
Thanks, Sarah. The big question, will the slides be shared? Yes, you will be getting something tomorrow from the tax. You can check the tax section homepage. The slides, the webinar recording, our bios, they'll be available tomorrow morning. Yes, and you can print them out if you want. So it will be available. So this one, I'm not sure what this is, but Sakina, I think you answered this. Wait 6 years from when we received the SSN. Or Sarah, I think you answered this. I'm not sure what that is pertaining to.
Can you repeat the question?
It just says wait 6 years from when we
Oh,
received the
I think that
SSN.
was,
I think Sarah answered that question.
Yeah, I think Sarah answered that one. Yeah.
Potential criminal activity, Sarah?
right. So the issue is when you file your SSA 7008, Social Security Administration does not have those privacy protections that the IRS has. So when you file a tax return and you're undocumented, you can rest assured that that information will not leave the IRS. Those same precautions are not in the Social Security Administration. So the idea is that if there was any crime committed with the use of an invalid social security number, you want to wait out that statute of limitations before filing this SSA 7008. It's a very, very low risk of prosecution. I've talked to Social Security administrators about this and they're like, nah, that never happens. But I do think it is a risk and that we should advise our clients about it.
Okay, thanks. And then either for Sam or Sarah, if a legal permanent resident is applying for citizenship and their spouse is undocumented, can the LPR spouse be filing as head of household or single? Although they are legally married to their undocumented spouse, will they face issues when USCIS is reviewing their tax return for the last 5 years? Sam, you want this one?
Sure.
Yeah.
First question is, do they live with the spouse? If they live with the spouse, the answer is you can only file as married filing jointly or married filing separate. If they have lived apart from the spouse for the last 6 months of the prior year and one of their children lives with them and they support the household, they could file as head of household. I've never, ever seen that legitimately, ever. And so, and then the question would be, why are you having an interview today when you don't live with your spouse unless they're abroad? Okay. I've also never seen a situation where one of the dependents or exemptions or children live with the USC or the LPR in the United States when the spouse lives abroad. That would be the scenario when I think it could happen, but I've never seen it because I think it's really rare. But so if that situation comes up, they just probably need to fix the tax returns.
Okay, thanks. All right, Sakina or Sarah, this one, is there any scenario where a US citizen spouse can file head of household when their undocumented spouse lives in the US or when their spouse is in the US with a valid SSN?
I think Sam touched on the answer, but I think me and Sarah actually answered this question in the chat. But it depends. So based on what Sam said, if you are a US citizen, you are married, you have two options to file as married filing separately or married filing jointly. But you can file head of household, like Sam said, the exception if you lived apart from your spouse more than 6 months throughout the year. And you have a dependent that you take care of and you support the household. That's how I see that coming into play.
Okay, thanks.
You're welcome.
And then can you get CTC with amended return after you get the child's social security number?
The retroactive claim to the additional child tax credit once you get the kid's social security number.
I can take that one, or
That was a good
Sakina, I
question.
think.
Yeah.
My understanding is that you have to apply for the social security number. You have to receive prior to the original due date of the tax return. And so if I understand this question correctly, this is someone that received the social security number after the due date of the tax return. And my understanding based on IRS publications and guidance is that you're unable to amend the return because you received the social security number after the original due date for the tax return.
Okay, thanks.
I will just add on to that, that because you have to have the social security number before the due date of the return, it's very important, I'm just reiterating, it's very important to file an extension for the tax return so that you have that extra 6 months in case the social security number comes between April 15th and October 15th. I would even think that if you advised a client on a tax matter and that was happening and you failed to tell them to file an extension, I think it could be considered malpractice. So
Wow.
Yeah.
Thanks, Sarah, for scaring us. I'm just-
sorry.
All right, this is for Professor Tillman for undocumented I-10 applicants. I was advised to have them check H on the W-7 form and write in individual who is a resident alien for tax purposes, and then write and has an interest-bearing account that generates income, or and must pay taxes on wages, then include supporting documentation. Is the supporting documentation necessary for approval of the W-7?
So I answered this question in chat. You want to provide the supporting documentation to prevent any delays, but my experience that if you don't support that, then they can tell you to submit it. That's based on my understanding and applying for the I-10.
Okay, thanks.
You're welcome.
Sam, you answered this one in the chat, but further issue of the strategy of using the I-864W to replace the I-864 when the petitioner has no income or little income and the beneficiary does not have lawful income. Declare the undocumented spouse's income on the U.S. spouse's SSN number. Legitimately, of course, such as when there is a family construction business and the petitioner is doing the books, taking calls from possible customers, etc. Twist on facts, the U.S. spouse or their child draws some sort of disability or public benefit.
So I know this immigration lawyer, and he is an excellent immigration lawyer, by the way. So he has been practicing this area for a long time and takes all these hard cases. So the answer that I think I put out there was, I had a similar case recently where I had a USC who was the petitioner who was receiving, he had a military benefit and which was not taxable, and it was not on the tax return. And the way that the I-864 is written now is it asks for your income from the tax, your adjusted gross income. And so he didn't really have any. I mean, he had like a little bit, but not really any. So I just kind of crammed it. And then I wrote it, his retirement on there. And then I attached it as an exhibit and wrote, you know, in the back in one of the explanations, hey, the big picture here is what is their income? This is his income. He would qualify, in my opinion. And we did get an RFE. So I wanted to kind of fight this issue out, but then I had to withdraw as counsel. So I never did get the answer, but that's what I did. Before we filed the case, we saw the issue and told the client, it's possible they're going to bounce this because you don't have income from a tax return that shows what your income is. So, you know, you might ultimately have to get a joint sponsor, which is kind of where we were going in that direction. So I wish I had a better answer, but you know, that's what I did in that particular case. Back to Sarah's point about tax advice. I think I'm glad she brought that up. Some immigration lawyers put in their engagement agreement that they don't give any tax advice. And I think that's a good idea because they, you know, people always ask you, and I think and you might even say like, I don't give advice on tax tax. And I also specifically don't give advice on how to get, you know, make a claim for your Social Security benefits once you become documented, or actually help them do that. I mean, Sarah, you know, really kind of opened my eyes on this. And I think it's a really fantastic thing that really all practitioners could advise their clients that they have the ability to do once they get status.
All right, so we have a lot of questions, so I'll just throw some out there. I represent parents who were paroled in under C-11. They got EADs and SSNs. Their children are also paroled in but did not receive SSNs. Could they miss out on tax benefits if their children only have I-10s but no SSNs? I think, Sarah, you answered this one.
Okay. The answer is, you know, I think it's come up in a number of these questions that in order to access the earned income tax credit and the child tax credit, the child, everyone on the return for the earned income tax credit and the child for the child tax credit needs to have their Social Security number issued by the due date of the return. So the due date of the return is April 15th without an extension and October 15th with an extension. And we come back to file those extensions.
Thanks. Wafa, this one may be for you. Is there anything that needs to be said regarding diplomatic personnel and their families? Foreign consulate, embassies, UN, World Bank, et cetera, and their families, the latter who may be subject to US taxes?
Well, in general, the IRS allows the children and the family to be exempted from the substantial presence test. However, there are like certain particular qualifications for the children of, let's say, diplomats or World Bank employees' children. But this is more in detail, whether they were born in the United States and how they can qualify to become, if they elect to be green card holders, and then the tax implications. And that's by itself like a very detailed question. So I will opt from going into depth into that now. But I'll be happy to answer it later if needed.
No problem. So someone just wants confirmation. Once an individual has legal status who previously paid taxes through the ITIN, the individual should, number one, notify the ITIN unit in Austin, and then two, fill out the SSA 7008 IRS form in order to get full Social Security benefits. I think, Sarah, that was yours.
So I think the answer to the first part of that question is yes. Notify the IRS immediately of the Social Security number, stop using the ITIN, start using the SSN, use the SSN even if work authorization has expired. And the second part of that question is correct your earnings record. That doesn't have to be done right away. And I would just take a look and advise the client of the very minuscule possibility of prosecution prior to doing the earnings correction, but the earnings correction can eventually be done. It doesn't need to be done right away.
Okay. Is there ever a reason when spouses living together can file taxes as head of household with spouse as dependent?
If they're legally married, no.
Okay, thanks.
They have two choices: married filing joint, married filing separate.
All right.
I've had cases though, when the person was actually married to someone in Mexico and the girlfriend was living with the person and not working, and she qualified as a dependent. So maybe not ethical, but legal. Or maybe all the above.
Although now it wouldn't, I guess you'd still get the other dependent credit. You don't get any
Yeah.
dependent exemption amount now, so it
Yeah,
wouldn't
no,
really
it
make
was-
that much of a difference.
It was back in the old days when it was all more fun.
In what situations can a niece nephew be claimed for a tax credit?
I can take that one. So nieces and nephews do satisfy the relationship test. So as long as they satisfy the other tests of whatever credit, then yes, they would qualify. In general, that means that they have to live with them here in the United States in their household for more than half the year, and the child cannot provide more than half of their own support.
Okay.
Can we go back to this one real quick?
Yeah.
So this was a major area of non-compliance when I was still in the preparation industry. And so what we would do is we would have people bring in school records when they were applying for the ITIN. Actually, you have to submit two things, and one could be school records. And we would use the school records basically to figure out if they lived with the client. Because if the school records were from Mexico, obviously they were not living with the client. So like sometimes the client would say they live with us, and we would say, well, these school records say they were in Mexico yesterday. So like, that's not the case.
Right, but they could qualify as dependent exemptions. They just,
Yeah, they could. Yeah, no
they
question.
wouldn't qualify as for the earned income tax credit or the child tax credit unless they're living in the same home.
Great, correct. And it came up back then because you wouldn't get any money back if you had nothing withheld, if you didn't claim the child tax credit, which meant they were living with you. So if you were just claiming someone as an exemption, it didn't do you much good. But so if you have nieces or nephews, the question is always going to be whether they lived with the taxpayer. And so that's what you need to ask your client. If those tax returns are not going to get changed and it's a cancellation case, there are two things that the government goes right to in the description of the dependent. And one is other, if it's other or niece and nephew, and the tax software actually automatically, at least the one we would use, default to give the additional child tax credit, or the child tax credit, which is also the additional child tax credit, depending on some things. So the tax software would just automatically do it. And so you have to kind of deselect it. So if you see niece or nephew or other on the tax return, you got to ask your client, where did they live?
Right.
Look at that box to the right. If it's checked and they didn't live with your client, then you probably need to circle back.
And I will just add to that, Sam, in general, I find with my clients, if you ask them, do the niece and nephew live with you in your home? You can trust what they say. If they say yes, you don't have to get the school records necessarily.
Well, this was in the context of applying for an I-10 at the same time.
Okay, yes,
Yeah.
yeah.
So we weren't
And they'll
like,
tell you no, they'll tell, I mean, my clients are pretty honest with they're honest with you. They'll tell you.
yeah,
So
they
you can
typically
just-
will. Yeah. I had this, I was just talking about this one particular person. I mean, but
I just don't want to bash on our clients.
No.
too much, that's all.
It was not our clients who were doing it. They really didn't know. They would just go someplace and give them the tax return
Exactly.
and say,
It's usually when there's
this-
problems on the tax returns, I would say over 90% of the time, it's the tax preparer's fault. It's not, our clients are just trying to do the right thing. Honestly, they want to be compliant with their tax filing obligations and trying to do it. And it's the tax preparers that are trying to maximize refunds, I would say.
All right, I have a Nats question here. I have an LPR client applying for naturalization with back taxes owed to IRS. He says he submitted a form to IRS to formulate a payment plan in December 2021 and no response from IRS. His accountant says lack of staffing. He is making payments but doesn't have a signed installment agreement. Is there a workaround so that he can file for naturalization? So, does anyone know the answer to that?
okay, so this, I can take this one. This is similar to cancellation cases where the people have to have the tax records submitted by a filing deadline, which is 30 days before the hearing typically. And they come to us 2 days before the deadline and say, can you do the tax returns? And we submit them, and the council says, I need proof that they have an installment agreement. And we say, that's not impossible, or that's impossible. The tax returns have to get processed, and then you have to apply for it. But there are many cases when we filed back tax returns like 10 years, and they never got processed ever. And so what we do in applications for installment agreements, if possible, I would have them apply online and then print out the screenshot that shows it was applied for. If they are mailing it in, I would have them take the sticker off a certified receipt, put it on the actual application for the installment agreement, make a copy of that, and then submit that either in the NATS application or to the court that shows that they mailed it in, because you cannot. Now, if I bash the IRS here a little bit, Sarah, you're gonna get mad at me. Okay, so
That's okay, you
cannot
can do
rely
that.
on the IRS to respond to things. So in the cover letter is I write, my client did everything possible to file these tax returns, and they may or may not ever be processed. And then I say, as proof, here is the certified proof of the certified letter that went in. Here's a copy of the tax return. You can see it was on the front page of that. and here's where it was delivered to the Austin Service Center on this day. And I would suggest the same thing with installment agreements, that anything you ever send and just say, you know, all we could do is we filed it and we're waiting.
What, you mean that the Immigration Service and the IRS don't talk to each other, Sam?
Let's hope not. They're not supposed to.
All right, we have 5 minutes or 4 minutes, so I'm just going to ask each panelist to give us a quick takeaway that they'd want someone to take away from this 90-minute panel. So we'll start with Sakina.
Oh, wow. There's a lot. I really enjoyed this panel with everyone, but I think the takeaway for me is when it comes to tax preparation, making sure that you file the correct tax return, whether it is a Form 1040 or 1040 NR, in addition to making sure that you had the correct filing status. Those are the 2 issues that I see come about as it relates to immigration and taxation.
Thanks, Sakina. Sarah?
File an extension. That's my takeaway. Do it. File extensions, especially for your clients waiting for their social security number.
Okay. Wafa?
Mine is to advise your clients when they're seeking non-immigrant visas, particularly L's and E's and H's, to seek advice from a CPA about their taxes and their compliance with the substantial presence test. And again, also with investors, it's quite crucial that they seek advice.
Thanks, Wafa. And then Sam?
Most tax sins, intentional and unintentional, can be forgiven by filing a 1040X before they're brought to your attention. So if your client has done something intentional or unintentional, and I would assume it's unintentional, just file the 1040X, resolve the situation, and then you have taken the sting out of everything.
Thanks, Sam. So I want to thank everyone for joining our webinar. I want to express our gratitude to our wonderful group of panelists. You're doing such great work, and thank you for taking time out of your schedule to share your experiences. The Commission on Immigration provides free webinars and resources for legal professionals and advocates nationwide. We hope this helps you in your work, also for the tax section as well. And again, if you can, please consider joining and becoming an active member in the ABA. It's been my pleasure moderating this webinar. And again, we will provide an email with all the links, the wonderful house of cards, the presentation, the recording, and all our bios. So best of luck to everyone in your work today. Hopefully you got some nuggets of information and can utilize that in your practice areas, and stay safe, everyone. Thanks, everybody.